Hi everyone. This is a training for Citizenship Day volunteers to learn how to properly complete the N400 application for citizenship. A little bit of an overview of this training. We're going to go over what to expect at a OneAmerica ALA Washington Citizenship Day, some of the benefits and barriers associated with applying for U.S. citizenship, the legal requirements for citizenship, and then finally, how to complete the N400 citizenship application form. Before you proceed further, we recommend opening the attachments you received in your email so you can refer to them as we proceed through the presentation. This is the Citizenship Day screening and intake form and the N400 application for citizenship. What is Citizenship Day? Citizenship Day is a day-long free legal clinic to help eligible legal permanent residents apply for citizenship all over Washington state. Citizenship Days were founded back in 2004 by the ALA Washington chapter and have been run in partnership with OneAmerica for the past several years. Citizenship Day is one of the only free citizenship services that's still in existence. And since 2008, more than 5,000 people have received free services at Citizenship Day. Now we're going to go over what to expect at a typical Citizenship Day. At 8:30 a.m., all volunteers should arrive for site orientation and coffee and some breakfast. Around 9 a.m., sometimes earlier, clients begin lining up. We distribute intake forms so that they can start filling those out. The doors officially close to clients around 1 p.m., but you should expect to stay until about 5 p.m. or sometimes a little bit later to finish up with the clients that we have. Starting at 10 a.m., when the event officially opens, we'll seat the first group of clients with attorneys one-on-one to start their screenings. You, as paralegal volunteers, will receive your first clients as soon as this first round of screening is done, and those can take anywhere from 20 minutes to an hour. We really appreciate your flexibility because sometimes the volume of clients will ebb and flow throughout the day, so thank you for that. There are 6 basic stations at every Citizenship Day site that clients need to proceed through. The first station is the intake station where they'll get an intake form. The next step is a legal screening by an attorney or a BIA accredited rep. Then they'll go to you to complete their N400 form if they're eligible. After that, they will see another attorney or BIA accredited rep to complete quality review, basically checking that the application was completed properly and that the client doesn't have any legal issues. Then they'll proceed through the copy station where they'll get a full copy of their application, and then finally to the exit station where we'll take their photo and give them any additional resources. You'll see that there are room captains or other volunteers who intercede throughout the process. Those room captains are responsible for moving the clients through the process in the correct order, giving you clients when you're available, and breaking you for lunch. So Station 1, the intake station, this is where a client will check in when they first arrive. The intake volunteers should do a basic check to make sure that the client is there to apply for citizenship. This is not a day for other immigration consultations. This is only a day for citizenship applications. And the intake volunteer will make sure that the client has a green card and that the green card is old enough to make them eligible to apply. Then the client is given this yellow and blue intake form packet to start filling out. And there's a screenshot of it there. This is the first page, the yellow page, and it is several pages long. Station 2 is where the client will meet one-on-one with an attorney or a BIA accredited representative. At that station, the attorney or BIA accredited representative will review the client's intake form, the blue section that the client has filled out, and review their biographical data, how old they are, where they're from, what their marital history is, their address history, travel history, and then most importantly, any criminal issues or other good moral character issues that could cause problems for that client throughout the process. The attorney will review and sign the limited legal advice agreement with the client. This basically says that They are there to provide legal advice and application assistance that day only, but they are not representing the client, and it is up to the client to continue with their naturalization process after they leave Citizenship Day. At the rest of Station 2, the client and the attorney are going to proceed through this yellow screening questionnaire on page 1. The attorney will ask the client questions, and the attorney will actually complete this. And the point of this is to identify any potential red flags that could make this person deniable for citizenship, or even worse, deportable or removable. Those are not the kind of clients that we want to put forward at Citizenship Day, and so the initial screening station is there to identify those issues. If there are any eligibility issues, or if it seems risky for the client to apply without representation, then we refer out to a number of different nonprofit organizations who can help that client on a one-on-one, more intensive basis, or to private attorneys. If the client has any what we call acceptable criminal issues, meaning minor issues that they can explain safely on their own in their interview without representation, then the attorney may pre-fill out page 14 of the N-400, which is the criminal chart. This is not something that they need to do, but they may do that to make it easier on you to fill out when the client comes to you. The attorney or BAA accredited rep will also review the client's green card and any supporting documentation or records that they brought with them to make sure that they are okay to proceed to application completion. Station 3, forms completion. This is where you come in as the paralegal. The first thing that you'll do is you'll sit down with the client and review their yellow and blue intake form. Again, the blue part will be filled out by the client, and the yellow form on the front page is what the attorney notes during their eligibility screening with the client. So you want to review any issues that are flagged by the attorney and anything you notice about the client's intake form that you'll need as you're completing the application. Then you'll begin filling out the N-400 application for citizenship. At most sites, this will be done on the computer, although at some sites we use paper forms, and you will sit with the client ideally next to you so that he or she can look and make sure that you are completing it accurately. If there's anything that you are in doubt about as you're filling out the application, any question that you're unsure of, please leave it blank, and you can use one of the sticky notes that will be provided to you at your station to flag it and write a note for the quality review attorney. Remember, every client who you fill out an application for, they will meet again with another immigration attorney after you to review the form. So you can leave as many detailed notes as you feel are appropriate so that the attorney can understand what your thinking was and what issues you found or what areas you were unsure of. If you find that a client needs assistance with the fee waiver, if you've watched the fee waiver training video, you can go ahead and complete the fee waiver application with them as soon as you're done with the N-400. If you do not know how to fill out the fee waiver, then you'll want to flag down the room captain, volunteer for your station, and get the client in line for another paralegal who can do the fee waiver form. Just a quick note about filling out forms on the computer. Generally, the blank N-400 form will be pre-saved to the desktop of your computer as a PDF. You'll want to open it in Adobe Reader to fill it out. Please be sure that you don't accidentally open it in your browser or via Dropbox in preview mode, because those changes will not save. I'd also recommend filling out a page or two, saving and closing and reopening to make sure that all your changes have saved, because it is quite a long form and it's really a shame when you get to the end and all your changes haven't saved. You should save it to the desktop of the computer and to a USB flash drive, which will be provided to you just for extra assurance that the form is saved. Please save as client last name, client first name. We'll review all of this at your on-site orientation, but this is just something to note for right now. When the application is done, you'll print the completed application, add the sticky notes to the appropriate sections if you had issues or you were unsure of anything for the attorney to look at, and then you will flag down the room captain and let them know that the client is ready for quality review. Remember, the client should leave with a printed application and the USB flash drive with the application saved on it for the quality review attorney. That way the attorney can review the printed version of the form, and then if they need to make any changes, they can open it electronically from the flash drive and make those changes. Finally, and almost most importantly, is that yellow and blue intake form will have a checklist where you need to fill out exactly what you did with that client. This is what it looks like. It's on the second page of the yellow part, and you'll want to check that, yes, you completed the N400, that you noted any red flags or missing info for the quality review attorney, that you gave the client a copy of the oath of allegiance. These will be sitting out at your station. If the client needs assistance with the fee waiver, please check yes or no, and then you'll want to put your name and sign here. If you proceeded to do the fee waiver for the client, then you can indicate that below. Otherwise, the next paralegal will need to complete the fee waiver checklist. It's really, really important that this intake checklist gets filled out, especially with your name and signature, because sometimes later on in the day, the attorney may have a question for you, or they may be missing an application or missing a page, and they need to track you down, and we need to know who completed that client's application. So once you're done with the client will proceed to Station 4, which is where they'll meet with an experienced immigration attorney or BIA accredited rep to review their application that you completed. The attorney is going to go through every page of both the N400 and the I-912 fee waiver to make sure that everything is completed accurately and there aren't any issues that were perhaps missed by both the screening attorney and the paralegal. And we're particularly worried about things that could cause not just denial of naturalization, but also potentially trigger removal proceedings against the client. The quality review attorney will take a look at the supporting documentation and the client's green card once again. They will sign the preparers section as the attorney, and then if the client is okay to move on, they'll flag down a room captain, and the client goes to the next station, which is the copy station. Here, the client will get a full copy made of their N400, all the supporting documentation that they brought, and they will get their full application packaged in a certified mailing envelope to send to USCIS after the event, and a full copy for themselves for their own records. Finally, the client proceeds to the exit station, and this is where we ask clients if we can take their picture. We give them resources like flashcards to study for the civics and history exam, information about knowing their rights with Immigration and Customs Enforcement, things like that, and then they're done for the day. Here are some benefits of U.S. citizenship. These are not the only benefits, but these are certainly some of the chief ones. Once someone becomes a U.S. citizen, they can access public employment, federal jobs. Some state jobs are only limited to U.S. citizens. They can access certain public benefits, including federal financial aid for college and graduate school. They are finally safe from deportation. U.S. citizenship, once granted, can't be taken away. They can travel on a U.S. passport, so they don't have to worry about time limits and losing their residency by going back for long periods of time to visit their families. If they have any children under 18 that are living with them and that are legal permanent residents, those children will automatically become citizens. And then they can also more easily reunite their family members who are abroad once they're U.S. citizens. Finally, and these are some of the most important ones, as U.S. citizens can vote, and they can also run for public elected office. I just mentioned this, but children who are under 18 automatically become citizens, no application necessary, when all of the following are true. At least one of their parents naturalizes. The child is residing in physical and legal custody of the citizen parent, and the child is a legal permanent resident. So there are a ton of benefits to becoming a U.S. citizen, but the statistics don't really show that many people apply for citizenship. There are actually 263,000 green card holders in Washington state, but less than 10% of those have applied for citizenship. Well, the cost is a huge issue. The application form, if you don't qualify for the fee waiver, costs about $680 to file, and then if you need to retain an attorney to represent you through the process or prepare your application, legal fees can be $1,000 or more. In 2016, the N-400 filing fee is expected to increase to $725. A lot of people don't have the requisite level of English in order to be able to naturalize. Legal assistance is not available, particularly in remote areas of the state. There's quite a bit of fear and misunderstanding about the process that can scare people away from applying for citizenship. And then finally, and we'll go into this later as we talk about the legal issues, it can be really complicated and risky to apply. By applying for U.S. citizenship, you invite U.S. Citizenship and Immigration Services to take one last look at your background, and certain people with particular criminal and civil issues can actually trigger their own removal from the United States by applying for citizenship. So here are the basic eligibility requirements for a legal permanent resident to be able to apply for U.S. citizenship. You do have to be 18 years old. There are certain residency requirements, physical presence requirements, meaning how many days did you actually spend in the U.S. over the last 5 years. Most people must speak, write, and read English. You have to demonstrate a working knowledge of U.S. history and civics. You have to be willing to take the oath of allegiance to the United States. And then finally, and this is one of the most complicated aspects of applying for naturalization, all applicants for naturalization must demonstrate what's called good moral character. And good moral character is much easier said than actually described or put into practice, and we'll go into that over the next few slides. Here are some examples of legal permanent resident cards, more commonly called green cards. And they've changed in format over the years, but they all have a few things in common. The person's A number, it's called the alien number, and that's sort of the identifying number for someone who's a legal permanent resident. It'll have the date of adjustment or the date that the person became a legal permanent resident. It should have the person's birthday, their country of birth, and the category, which is right here on the bottom left, which describes how the person obtained legal permanent resident status. So it might be as a refugee, it might be as an asylee, it might be through a family petition. There are a number of different codes that these correspond to. So in order to become a citizen, you have to comply with the continuous residence requirements, which state that you must be an LPR, a legal permanent resident, for the last 5 years. If you're married to a U.S. citizen and still married to that U.S. citizen, you can be a legal permanent resident for 3 years and apply for citizenship. This residence must be continuous. You are allowed absences for trips outside the U.S., but generally absences of 6 months or more may break continuity of residence. The person must reside for the past 3 months in the CIS service district or state where they filed their N-400. And USCIS does permit you to apply 90 days before your residency period comes to 3 or 5 years. However, there is one exception. If you're applying based on your marriage to a U.S. citizen, you must complete 3 full years of marriage to that U.S. citizen before filing your application. So for example, if someone obtained their legal permanent residency status in March of 2010, they would be eligible to apply for naturalization in January of 2015. And so that's 5 years minus 3 months or 90 days since they became a legal permanent resident. Physical presence is a little bit of a different issue than conditional residence. Physical presence doesn't relate to where your primary residence is. It says where were you physically over the past 5 years. And the rule is you must be physically present in the U.S. for at least half of the previous 5 years or half of the previous 3 years if you're married to a U.S. citizen. So if you are applying under the 5-year rule, then you cannot have spent more than 912 days outside the U.S. And that is cumulative. So multiple short trips or a mix of short and long trips, all of those days will add up, and you are not eligible if you've spent more than 912 days outside. For the 3-year rule, the rule is 547 days outside the U.S. Now, the good moral character component of naturalization eligibility is really complicated, and the purpose of showing you this is just to demonstrate how technical and complicated it can be to apply for citizenship and to analyze someone's criminal history in order to determine if they're eligible or not. There are crimes that seem to a layperson much less serious than others, and those can trigger deportation. And then there are certainly crimes that seem a little bit more serious that do not impact someone's naturalization eligibility. I'll just review these very briefly, but these are items that the attorneys who see your client before and after should be taking a close look at, not the paralegal. So these are a list of mandatory bars, which mean that if any of these apply to you, you are not eligible for citizenship. Anyone who has been convicted of an aggravated felony after November 29th, 1990 is not and never will be eligible to apply for citizenship. And then if you have any of the following on your record within the 3 or 5 year statutory period, you are not eligible to apply for citizenship. And also, if you have any of the following on your record within the last 3 years or 5 years, depending on the period that you're applying under, you are not eligible to apply for citizenship. If you've ever been convicted of or even admitted to a CIMT, which is a crime involving moral turpitude, you are not eligible to apply. If you have committed 2 or more offenses where the aggregate sentence was 5 or more years, you are not eligible to apply. And the same goes for any controlled substance violations, any convictions that resulted in more than 180 days in jail, false testimony given to gain an immigration benefit, and then a host of other issues, prostitution, alien smuggling, or helping someone who is not a legal resident to cross the border, involvement in polygamy, being a habitual drunkard, or involvement in illegal gambling. This is a list of offenses that are not necessarily mandatory bars to citizenship, but can be used at the officer's discretion to determine that this applicant does not have good moral character. And those are things like giving false information to a government official, failing to pay child support, ever registering to vote or voting, or claiming to be a U.S. citizen in any way, failure to pay taxes, failure to register for the Selective Service or draft, and then there's sort of a catch-all component, which is called other criminal violations or unlawful acts. So other criminal issues or offenses that are not described here can still be used as discretionary bars to deny someone citizenship. There are certain issues that jeopardize someone's immigration status. If they come forward and apply for citizenship, they could actually be put into removal proceedings. So anyone who has any of the following on their record should not apply for citizenship. And those are people who have committed an aggravated felony, who have ever falsely claimed U.S. citizenship, given false or misleading information to the government, committed a crime involving moral turpitude within 5 years of admission to the United States, which is sometimes but not always the date on which they got their green card, voting unlawfully, or obtaining their green card unlawfully. These are the kind of issues that we want to catch at the screening station at Citizenship Day, and we want to make sure that these people know that they should not apply for citizenship at our event or with any other means. There is an English language requirement for most people to be able to successfully apply for citizenship. At the interview, which takes place anywhere from 3 to 6 months after filing the application, the officer is going to ask the applicant questions about the content in their N400 in English. There's a small writing and reading test in which the applicant must write a sentence that's read to them in English, and they must read aloud a sentence that's given to them in English. The history and civics component, the applicant will have a list of 100 possible questions about U.S. history and civics. They have that in advance and they will study it before the interview. The test is given verbally. The officer will ask 10 questions and the person needs to answer 6 out of 10 correctly during the interview. There are exemptions available for people who meet these requirements. So if you are at least 50 years old and have 20 years of residency on the date of filing, or if you're at least 55 years old and have 15 years of residency, then you can do the interview and answer the civics and history questions in your own language. You still need to study 100 questions, but you can study them in your own language and answer 6 out of 10 correctly. For short, we call these the 50-20 exemption or the 55-15 exemption. It's really important that someone meets both of those requirements. So if you're 55 years old, but you only have 6 years of residency, you will not meet the exemption. You must have both the age and the residency. There is a more comprehensive exemption for folks who are a little bit older. If you're at least 65 years old and have at least 20 years as a legal permanent resident, we call this the 65-20 exemption, then you'll do the interview in your own language, and you only need to study 20 questions instead of the full list of 100. So of the 20 questions, the officer will ask the person 10, and they still must answer 6 correctly. Finally, there's something that's called the N648 Disability Waiver Form, which is available for people who cannot learn history, civics, or English because they have a medical condition. Anyone who says that they are seeking to apply for that should be referred out. A doctor has to evaluate the person to see if they meet this requirement and complete the form. We don't do N400s at Citizenship Day for people who need the N648 disability waiver. Now we're going to talk about the entire N400 form. We'll highlight particular sections that may require special attention or raise legal issues. So now is a good time to get your N400 form out so you can follow along. As a reminder, we usually complete these electronically at Citizenship Day, but if you're completing them on paper, you should always use black ink and write in all caps. Okay, so this is page 1. This is where you're going to select which provision you are applying for citizenship under. So if the client has been a legal permanent resident for at least 5 years, you'll check A. If they've been a legal permanent resident for 3 years and married to a U.S. citizen that whole time, you'll check B. Generally, if someone is eligible under both, we check B because the statutory period that will be reviewed for that client is shorter, 3 years. Ultimately, the rest of the form will be completed in the same way for both. For part 2, current legal name and your name exactly as it appears on your green card, sometimes the permanent resident card has the person's name a little bit differently. It is important that you document the client's name exactly as it appears on their card, and then if their legal name is different, then you will write the legal name on number 1. On the next page, this is some biographical information about the client. You'll look at the client's green card to put the date that they became a legal permanent resident. And then number 12, this is a question about the N648 disability waiver. It should be no. If you have any clients who want to seek the disability waiver, stop completing the application and notify the room captain so that client can be referred out. Question 13, exemptions from the English language test. If your client meets any of these exemptions, please check their age and length of their legal permanent resident status so that you can check the right boxes for this. Part 3 is related to accommodations for individuals with disabilities and/or impairments. This is very different from question 12 about the disability waiver. Question 12 indicates that they have a physical or mental impairment that prevents them from learning English or learning U.S. history and civics. Part 3, question 1, is only for people who need accommodations like an American Sign Language interpreter if they're deaf, accommodations if they're blind, if they cannot sit for a long period of time, that can be indicated here. But those are people who will be completing the interview and the test more or less as required, but they're requesting smaller accommodations. This next page, I'm going to skip to part 4. Please fill out as many contact information items as the client has, so that way USCIS can get in touch with them if they need to. Part 5, information about your residence. This is very, very important. Their current physical address and then their current mailing address. We often meet clients who have a physical address in a rural area, but they get their mail at a P.O. box. The mailing address is what USCIS uses to communicate with them about their fingerprint date, their interview date. everything about the process, and it's really important. Check with your client 2 or 3 times to make sure that this is an address that they can receive mail under Part B. If it's not an address where they can receive mail and USCIS sends notices to the wrong address, then the client could have their case administratively closed because USCIS is not hearing from them. If you miss your interview date, then your case will automatically be closed, so this is really important. If someone cannot remember the dates of their residence, it's okay to be a little bit more general. Try to ask them when they remembered moving there, what season it was. Try to get as close to it as possible. If someone can remember that it was in the spring, for example, what you can do is leave the dates of residence blank, and when you print out the form, you can fill it in by hand and say spring 2005 or something like that. The PDF will only accept dates in the format of the month, date, year. Okay, the next page is the space for more addresses. Remember that this is the client's residency history that should go in reverse chronological order. So I'll go back to the previous page for a second. We start with their current address and then we work back from there. So C, physical address 2, should be the place they lived before where they live now, and then this one should be the one before that, and so on. You want to make sure that the dates of residence match up exactly, so there should be no gaps in residence. There shouldn't be any period of a month or more where the client does not have a residence. That will trigger USCIS to potentially return the application for the client to correct it. If the client has moved many times in the past 5 years, they may have more addresses than will fit on this form. If that's the case, we have pre-prepared addendums on site that look just like this, and you'll fill the rest of the client's addresses in that way. Remember, you'll need to put in 5 years worth of residence for this section. Part 6 is information about your parents. This is where the client will need to put information about their parents, and particularly whether their parents are U.S. citizens. This is where USCIS is trying to find out if this person is potentially already a citizen and doesn't know about it yet. It's rare, but it happens. Sometimes the person will not be able to remember their parents' date of birth, or they don't know their mom or dad's A number if they have any. If that's the case, you'll just want to mark it with a sticky note after you print it to make sure that the client knows that they need to fill that in later and they don't leave it blank. Part 7, biographic information. This is for USCIS to be able to run a background check with the FBI and using the client's fingerprints. It's especially important if someone has a common name. For ethnicity, you can explain to your clients that unfortunately Hispanic or Latino versus not Hispanic or Latino are the only options that USCIS gives. The client does need to choose one. The next page is Part 8, and this is where the client will document all of their employment and or schools that they've attended over the last 5 years. One thing that's really important to note is that you must document periods of unemployment as well. And the history should be just like the addresses in reverse chronological order. So with number 1, you're going to start with where the person works or goes to school right now, or where they worked or went to school most recently. And then the next entry will be the job or school they had right before that, and so on. All of the dates when you're done with this section should add up exactly so that the entire period over the last 5 years is covered. It may be easier for this section to start with a list on paper with the client, especially if they have more than 1 or 2 jobs, just to make sure you have everything together before you enter data on the form. If you start entering on the PDF and then the client needs to insert another job that they forgot about later on in the process, it can be kind of tedious to cut and paste and add that in. So I would start with written document first, and then you can transfer it to the PDF once you're sure that all the jobs are in there. If a client is a stay-at-home mom, you can put that in too. They would use their own address. The same with self-employment. If they are retired, they should put the last job that they did have. Again, if the client has too many jobs to fit on this section, there are only 4 or 5 entries. We'll have pre-printed addendums that you can fill out for the rest of the client's jobs. The next section is travel outside the United States. This is where you will take a look at the client's passport if they haven't made a list of their trips for you already, and make a total of the total days that the client has spent outside the US during the last 5 years. This chart is to be completed with the dates of travel. This should be complete on the client's passport. Again, it may be easier for you to make a list on paper by hand first to make sure you have the full travel history before you start entering those trips on this chart. There is an online trip calculator or date calculator that we'll post the link at the event, and you can use that to automatically calculate the travel, which will be easier than doing it by hand. Remember, if the total number of days outside the US is close to 912, you'll want to flag it for the attorney, as well as if you have any trips that lasted 6 months or more. Both of those can be red flags. It's really common for some clients to not remember all of their trips, especially for people who have gone back and forth to a country like Mexico or Canada really often. If they can't remember the exact dates, have them try to list an estimate of all the trips that they've taken, and have them think about, how often they went, for how much time. And there's a travel addendum that we have prepared that says, I can't remember the exact dates of all my trips taken outside the US in the last 5 years. However, I know that I only traveled to X and X countries for no more than 15 days at a time, and I know that I was only outside the US for about 100 days total in the last 5 years. We have an editable version of that type of addendum, and you and your client can work together on that to come up with an accurate statement of their travel if they don't remember exactly the dates of their trips. The next section is marital history, and this is where USCIS wants to know exactly, they want to know everything about their current spouse and as well as previous spouses. Sometimes the client is not going to remember the current and especially ex-spouse's date of birth, date of marriage, but these are things to flag if you leave them blank so that the attorney knows to check this, and also so that the client can fill them in later if they need to. If the spouse is not a US citizen and doesn't have legal status, then you can check other and write no status or pending if they have a pending petition for them. If you run into something like multiple marriages in a short period of time, or a marriage that ended and then another marriage that began really quickly after, do flag that for the attorney, because that could be an indication of marriage fraud, and that could get the client in trouble in terms of how they got their permanent residency status. More marital history. We have a general supplemental addendum that's blank. If the client has more marriages than will fit on this form, you can use that to document them. When we go to Part 11, information about your children, there's sometimes confusion about this. People think that they only have to list children who live in the US or children who are under 18. All children need to be listed according to the instructions on the form. It doesn't matter if the child is alive, missing, or deceased, whether they were born in the US or in other countries. It doesn't matter where they live. It doesn't matter how old they are. Stepchildren, current stepchildren, and legally adopted children all need to be listed here. There are only 4 spaces to enter children on this form. Continues on to page 10. A lot of people do have more than 4 children, and again, we have a pre-printed addendum that you can fill in for any additional children. Okay, we're going to move on to part 12, which is on page 11. Now, this is a danger zone. These are questions that could lead to denial of naturalization and potentially the initiation of removal proceedings against the client. These are all questions that the attorney screener probably asked the client. However, it's important that you ask these again, slowly, using different phrasing wherever possible, and giving examples to make sure the applicant understands the question. Sometimes people are nervous when they sit down with their first attorney. They may not disclose everything. And then as they get to know you, as they fill out this form with you, they may warm up a little bit and share things with you that they may not have shared with the attorney. So don't assume that the client is telling both of you the same thing. And please do note anything that could be a red flag, generally any yes answers, for the quality review attorney to take a second look at. Now, some of these questions may seem really awkward to ask someone, especially someone you don't know well, and I find that it's helpful to give an introduction before you begin Part 12 and say something like, the U.S. government requires that everyone who becomes a citizen has to answer these questions. Some of these might be awkward or maybe don't apply to you at all, but I can't assume or answer for you, and so we have to go through all of them. All right, for Part 12, the first section talks about false claims to U.S. citizenship. So if anyone has ever claimed to be a U.S. citizen or voted or registered to vote, those are red flags and should be noted for the attorney to look at. Part 12 continues. They ask if the client owes any federal, state, or local taxes. Question 7, Part A, you'll see that it asks if the person has ever not filed a federal, state, or local tax return since becoming a lawful permanent resident. There may be people who did not earn enough money to file taxes. You can look up the IRS filing thresholds, but generally a single person who makes less than $10,000 a year approximately does not need to file. So if that's the case for your client, they didn't file a tax return, but they didn't have to, they still need to check yes. There will be, again, a pre-printed addendum that's already pre-written where the client certifies that I did not file my taxes in X and X years because I did not earn enough to be required to file. It's pre-written and the client will sign it and you'll include it with their application. Question 9 talks about membership in any organizations or groups. Obviously, the U.S. government is looking for things like terrorist organizations, anything related to violence, etc. However, this is a really good place to put any positive groups that the client may be a part of. So you may want to give the client examples so that they can start thinking about things like church membership, PTA, maybe their kids' soccer team, maybe they're part of a volunteer group. Anything like that is really good to put on this form because it helps weigh against some potentially negative good moral character information that may be on the form as well. 10 through 12 talk about violence and persecution. Again, if this happens, it'd be really important to flag for the attorney. 10A talks about, have you ever been associated with the Communist Party? If you have a client who may be from China or another country where membership in the Communist Party is required, there is a pre-written addendum for that that says, I was a member of the Communist Party, but it was compulsory in my country. The government, or USCIS, does know which countries require membership and which don't, but it's good to fill out this supplementary form if this applies to your client. Part 12 continues about any involvement in genocide, torture, violence, prison camps, detention centers, things like that. These questions can be quite long to read out, but it is important to read and ask every question to your client. This section continues with more questions about good moral character. 22 through 29 talk quite a bit about being convicted of a crime or any other offense. If your screening attorney has pre-completed this for you, just copy it. That'll be easy. The client may not offer it to you, but ask them to see if they have this pre-completed, and they may find that they do. For the chart in question 29, we are going to talk about that in a little bit more detail. But remember that, question 23 Have you ever been arrested, cited, or detained by any law enforcement officer? Citations include things like traffic tickets, not parking tickets, but things like speeding, failure to stop. Those should all be included. So if someone has even had a speeding ticket, they do need to check yes. It won't mess up their application in any way, but they do need to do that. This is the chart blown up a little bit in question 29. So here's an example of a chart completed for someone with a couple of issues. So they got a speeding ticket in 2015 in Yakima. They paid the fine and the case was closed. Do confirm with your client that they did pay the fine. They have proof of that. That's great. And then for this DUI that happened in 2001 in Seattle, we described that they spent 3 days in jail, paid the fine. If someone has any type of criminal issue in their background like a DUI, they should have the paperwork with them and they should have shown the screener attorney who determined that it was not serious enough to prevent them from applying for citizenship. Part 12 continues. These questions are some of the more awkward ones about prostitution, about polygamy, illegal gambling, things like that. Do ask all of these and try to rephrase and say them in a different way to make sure that you get the right answers about your clients. 31 through 36 about removal proceedings can be especially difficult to understand. The questions are written with a lot of technical language about removal, exclusion, rescission, or deportation proceedings currently pending against you. So ask them things like, have you ever seen an immigration judge? Did you ever go to immigration court? Did you ever have any trouble at the border? Did you ever try to cross the border or try to get back into the U.S. and have any trouble? What happened? Did they take your fingerprints? Any information about that you can get will be really helpful to the quality review attorney. If something happened with immigration at the border, they've ever been detained, write up as much as you can on a separate piece of paper from what the client described about the incident or incidents. You can leave this blank and put a note on it and ask the quality review attorney to investigate that issue a little more in depth. Question 38 is about active members of the military. We don't get too many military members at Citizenship Day, but you may see folks who these apply to. The tail end of Part 12 talks about registering for the selective service or the draft. A lot of people don't know, but anyone who is a male between the ages of 18 and 26 is required to register for the selective service, even if they were undocumented at the time. Anyone living in the U.S. who's male 18 to 26 is supposed to register for the draft. A lot of people don't know it. It's very common. So if you are working with a male applicant, the way that you approach this question is to first check their age. If they are between 18 and 26, then you can go to sss.gov, that's selective service, and you can check to see if they're registered by entering their social security number, or if they're not registered, you can register them on the spot. You'll just print the confirmation page and include it with their application. It's very easy and takes just a couple minutes. If the client is over the age of 31, then you have to take one additional step. There is a pre-printed addendum that will be at your station that says, I did not register for the selective service when I was between the ages of 18 and 26. I would have done so if I knew it was required, but I didn't know it was required. If that is true for the client, make sure that they agree with that assessment. They will sign it and you'll include it in the application. You may be wondering why 31 is the magical cutoff. Well, if we remember that the good moral character issue pertains most specifically to the last 5 years, someone who is 31, that means they failed to register more than 5 years ago, right? Because you can only register up to the age of 26. So that means that their failure to register was more than 5 years ago. It's not as much of a good moral character concern because that window has passed. Now, if you are working with a male who is between the ages of 26 and 31, that's when you have to take 2 extra steps because it's too late for them to register, but they failed to register within the last 5 years. So there is a small good moral character issue here. You'll sign the pre-printed addendum that I just mentioned, saying that they didn't know they needed to register. If they did, they would have. And then you have to do one extra step, which is request a Selective Service Status Information Letter. There are copies of these available at the station. It is basically a letter to the Selective Service certifying or requesting certification that this person is indeed not registered. It seems kind of unnecessary and counterintuitive, but it is something that needs to be done. You'll help the client fill it out and instruct them that they need to mail it when they're done with Citizenship Day. Generally, they'll get the certification letter back within 6 to 8 weeks, and they'll need to bring that to their interview. They can definitely file their N-400 while waiting for the letter. It's not a problem, but they should make sure that they send the request out soon so that they get this letter back in time to bring to their interview. Questions 45 through 50 talk about the oath of allegiance to the United States. There are copies of the oath available at your station. You should give one to your client. These questions break down each component of the oath. It is important that clients are willing to support the oath of allegiance to the United States. There are modified oaths available if someone has an objection to question 48, are you willing to bear arms on behalf of the United States? Since we don't have a draft anymore, this is a highly unlikely possibility, but if someone has a religious objection, they can request a modified oath from USCIS. Here's the example of the Selective Service Addendum. Again, these will be present at your site. Anyone over the age of 26 who is a man who did not register for the Selective Service should complete one of these and include it with their application. And again, if they're between the ages of 27 and 31, they also need to request the status information letter. Now, going back to Part 13, there is the applicant's statement and certification. This is where the applicant either checks A or B, that they completed this form in English, or if they completed this form in another language. So if you're using an interpreter to complete the form with the client, or if you yourself is the interpreter, so if you are talking with the client in Spanish but filling out this form in English, then you'll be the interpreter. So you will check either A or B for the client, filling in the language that was used if you used B. And then you will check box 2, but then leave the preparer's name blank, because remember, the preparer is actually the attorney or the BIA accredited rep who signs the form. We're nearing the end of the N-400 application. We're going to turn to the series of statements and certifications at the end of the application. The first one that we're going to find is on page 16. This is for the applicant to certify that they either understand English or they filled the application out in another language and they understand that language. So if you completed the form in English with your client, you will check A. If you used another language to complete the form, whether you used an interpreter or whether you yourself are bilingual and you did the form, let's say in Spanish, you'll check B and fill in the language that you used. The applicant statement regarding the preparer, which is number 2, please don't fill this out with your name. Wait for guidance from your staff representative at your workshop. This is either going to be the quality review attorney who reviewed the application, or it's going to be a OneAmerica staff person. In any case, though it may sound counterintuitive, you as the paralegal are not the preparer of the application. You may be the interpreter if you did the form in another language, but you're not the preparer, and this will be true every time we reference the preparer's statement going forward. Please do not put your name in number 2. We're going to turn to page 17, which is the next page. The applicant certification will continue. Please do not have them sign right here. They want to sign this after the quality review attorney has reviewed the application, because there may be changes that will be made to your work, and so you don't want to have them sign something that's not the final version of the application. If we continue down to part 14 on this same page, there is a statement that the interpreter, if you used one, will need to fill out. If you did not use an interpreter, you can skip all of this. But if you used a separate interpreter, their name will go in the name blanks. The business or organization will be OneAmerica, and then the mailing address information, that can be OneAmerica's address, city, and state. And that'll be provided to you on site, or you can look it up online on our website. If you used another language to complete the form, then you are the interpreter, and you can put your name here, and then all of the rest of the information will be OneAmerica's. On the next page, you'll see the interpreter's daytime telephone number. Again, this can be OneAmerica's phone number. The interpreter certification, you have to certify that you're fluent in English and the language that you use to complete the application. Again, you're the interpreter if you used another language. If you used a separate interpreter, they will fill this in. It does need to match whatever you indicated in Part 13, Item B, so make sure that you check the correct box and filled in the language on the previous page in order to fill this in properly. And the interpreter must sign here. Please don't forget to sign. A lot of times people will print the application, send the client on to quality review, and forget to actually hand sign it, but it does need to be signed. The preparer's statement is the last statement that we'll need to fill out today. Again, like I said earlier, it sounds counterintuitive, but the paralegal who actually completed the form is not the preparer. The quality review attorney or the OneAmerica workshop sponsor present that day is going to be the preparer. So please don't put your own name here. You can fill in OneAmerica as the business or organization name, as well as OneAmerica's address under the preparer's mailing address section. Those may be pre-printed for you, or you might need to fill that information in yourself. But again, your name as the paralegal should not go in the preparer's name. Turning on to the next page, there's a statement that the preparer will need to fill out. Please wait for guidance from your site coordinator on how to do this, but you will not be checking any of these boxes. They may come pre-filled out to you or not, but it is the quality review attorney or the staff person on site who will be the preparer. So don't sign here. And then on Part 16, you'll see a signature blank for the client. That should be signed at the interview. That is not to be signed today, and they will be returned if those are sent in signed. So please make sure to leave that blank. I've mentioned this several times in the presentation, but sometimes you may need to fill out a supplemental page or two, which is called an addendum, if the client has more information than will fit on the form. There's two different categories of addendums that I'll go through. The first category means the form just didn't have enough room for the client to fill in everything. So they may have more children, they may have more trips outside the US, they may have jobs that won't fit on the form, or they have too many addresses over the past 5 years. The other category, which are usually pre-drafted, are explanations about why the client did or did not do something. So there's the pre-drafted statement about why I didn't register for the selective service, why I didn't file my taxes, why I joined the Communist Party. And there's a blank addendum with just the client's A number and signature where you can write in something else that may come up that doesn't fit into any of those categories. Again, these are all pre-made. We have them electronically as well as printed and available at your station to use as needed. Sometimes it's easier to simply handwrite the addendum on paper and include it with the application. That is totally fine. It does not need to be done electronically. Want to go over just some general responsibilities of volunteers at Citizenship Day. Do remember that these are real clients who are putting their immigration status kind of in your hands. They have complicated stories, lives lived abroad in the US over many years, so please be careful and be very kind. You are the person who fills out the form with them and gains their trust. Please make sure to go through every question, asking in multiple different ways. Don't assume that the client will answer a certain way, and don't skip any questions. It's really important, we try to enforce this throughout Citizenship Day, that you should be working with the client alone. We don't want their friends and family to be seated next to them in the room. There may be things that they don't want to share in front of their family members, especially sensitive issues like criminal stuff, past marriages, maybe other children that their family doesn't know about. The only time we have family and friends in the room is if we need one of them to interpret for a language that we don't have an interpreter for that day. Trust your instincts. If you're in doubt about something, if something seems weird to you, flag it for the attorney. I want to say a few words about working with an interpreter. If you've never worked with an interpreter before, it can take some adjusting. You'll want to explain the procedure to both the client and the interpreter at the beginning. Say that this is a confidential space, nothing that you share with me will be taken outside of Citizenship Day. Emphasize the need for word translation. The interpreter should not be paraphrasing what the client is saying. They shouldn't be interpreting in a literal way. You know, she says this, but I think what she means is this. It needs to be word for word. Remember with an interpreter that you should be speaking slowly, pausing frequently to allow the interpreter time to translate. And look at the client when the client is speaking. Don't look at the interpreter. The interpreter should be almost invisible. You want to make sure that the client knows that you're working with them. There are translated versions of the N400 available at your station in Spanish, Vietnamese, Chinese, and Korean. If you're interpreting in any of those languages, please make sure the interpreter has a copy in front of them. It will be much easier for them to translate text that's already pre-written as opposed to thinking of it in their head. Remind the client also to pause for interpretation. Sometimes clients will go on and the interpreter can't possibly sum up what they've just said. And finally, remember that interpreting is really hard work, so give your interpreter breaks, especially in between clients, so they can get reset. There is a separate fee waiver training video that takes about 25 minutes, so we won't go into much detail about fee waivers, but once you're done completing the N400 with the client, ask the client if they know about the $680 filing fee and if they want to see if they qualify for a fee waiver. Not anyone can just qualify for a fee waiver. There are very specific requirements, and it is not worth applying if you don't fit one of the requirements because they will not be approved for the fee waiver. The client should have some sort of proof of eligibility with them. So receipt of public benefits, like a letter from DSHS if they get food stamps or Medicaid, or proof of income, which is probably last year's tax return. So here's who's eligible to apply for citizenship for free with the fee waiver. If you or your household receive means-tested benefits like food stamps, temporary assistance for needy families, or Medicaid, or if your household receives less than 150% of the federal poverty line in terms of income, and that has to be documented from last year's taxes, letter from your employer, or pay stubs. There's a quick screening worksheet tool at your desk that will be really helpful to confirm eligibility. Sometimes benefits can be confusing and it's hard to tell what's a means-tested benefit, what's not a means-tested benefit. That screening tool will help you. Again, there's a fee waiver training video that was emailed to all the paralegals. It's only 25 minutes, and it gives you really detailed instruction about eligibility and how to complete the fee waiver form. If you've watched that training video, please proceed to complete the fee waiver for your client right there. That'll be a lot faster. But if you haven't watched the video, you don't know how to complete the application, please do check to see if the client at least initially qualifies before sending them back to the room captain to get in line for another paralegal. You can ask them if they receive any benefits. If they say no, ask them what their household income is. If it doesn't fit within the guidelines, which will be at your station, it's not worth them applying for the fee waiver because they will not be approved. There are citizenship loans available from certain credit unions in the King County area, Tri-Cities area, and the Yakima Valley area. These are really great resources. They have low interest. They help build credit. If someone is really wanting to apply for citizenship but can't save in a reasonable amount of time, mention these to your clients and direct them to the resource table for more information. Couple last notes. There will be station instructions posted at each station. When you get to Citizenship Day, you may have a little downtime before your first client. Please take the time to refresh yourselves on the procedure. Make sure to watch your email. We'll be sending some important updates as the date gets closer. And of course, if you need to cancel for any reason, please let us know by email or by phone as soon as you know. It's really hard to plan the day when there are no-shows, and it will really help us if you tell us if you can cancel. Thank you so much for volunteering. Without your assistance, we would not be able to provide free legal services for people to apply for citizenship. Here's some contact information for members of the program, including our AILA Citizenship Day Chair, Margaret O'Donnell, and then the Washington New American staff.